Hello everyone, welcome to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. Jones Act injury cases, helping seamen injured off the California coast. The Jones Act is a federal law that gives seamen who were injured in the course of their employment the right to sue their employer for personal injury damage. Unlike almost all land-based workers, seamen are not entitled to workers' compensation benefits under either state or federal law. Because injured seamen cannot file workers' compensation claims against their employers, the only compensation that they are legally entitled to receive for their injuries is through the Jones Act and the General Maritime Law. This article will focus on the unique issues that come up in Jones Act negligent cases. Because seaman status is a difficult issue of maritime law, if you were injured at work and think that you might qualify as a Jones Act seaman, you should contact a maritime personal injury lawyer as soon as possible. The Jones Act allows an injured seaman to sue an employer for negligence. In order to recover damage from the employer, seamen must prove that the owner, captain, and/or crew of the vessels that the seamen worked on were negligent and that their negligence was a cause of the seaman's injury. Workers on cargo ships, oil tankers, and other ocean-going vessels with serious risk to their health and safety when they venture out on the high seas. Workers can slip and fall on slippery decks, get knocked down by rolling objects, or struck by unsecure equipment swinging loosely. Drivers go deep underwater to perform welding operations, risking lasting injury or death from the bends or other dangers. Special laws apply to maritime workers' injury on the job. The average personal injury lawyers or worker compensation attorney will not be familiar with the applicable laws and procedures that must be followed in order to recover compensation for a maritime worker's injury. California Jones Act attorney James Morris knows how these laws work and has been successful in recovering significant settlements and verdicts on behalf of injured workers in specialty occupations like seamen or railroad workers. If you or a loved one has been injured while working out on the Pacific Ocean or in California navigable waters, call the Morris Law Firm for advice and representation from an experienced and successful Jones Act lawyer. Almost all California employees are recovered by the state's worker compensation system. An employee who is injured on the job can receive workers' comp benefits that pay for all of their medical bills, plus provide wage replacement of 2/3 of their regular pay while they are disabled from working. Workers apply for and receive benefits without having to prove fault or negligence on the part of their employer or a co-worker. Even if the accident was the worker's own fault, they still get benefits for the on-the-job injury. Seamen are not covered by California workers' compensation, but they are not bound by workers' comp restriction either. An employee covered under workers' comp law cannot sue the employer for damage, even if the employer caused the accident through negligence. Employers still are limited to workers' comp benefits, which do not provide a full recovery from all the harm they suffer. Seamen don't have workers' compensation insurance and can't simply file a claim for benefits with their employer's insurance carrier. Instead, they must prove their claims, which include proving that the employer, a co-worker, or some other party was at fault in causing the accident. Injured workers can also sue the owner of the vessels when the vessel's unseaworthiness caused the accident. In this case, they don't have to prove the owner was negligent, but the plaintiff must still prove that the ship was dangerous due to the deck obstruction, design defects, understaffing, lack of supervision, unreasonably slippery decks, or some other hazard. Although the process to recover under the Jones Act is harder for the employer and the outcome is less certain than with a workers' comp claim, the potential recovery is greater. In a Jones Act claim, injured workers can recover money damage for losses such as their present and anticipated future medical expenses, the full amount of past and future lost wages, and harm such as pain and suffering, emotional distress, and loss of enjoyment in life. Workers may even be entitled to compensation for living expenses while they are recuperating from their injuries. The Jones Act applies to seamen, longshoremen, and other maritime workers who work in the service of a vessel on navigable waters for at least 30% of their time on the job. The Jones Act covers workers on any kind of vessels, from barges, tugs, and fishing boats to whale watching tour boats and cruise ships. First, commercial fishers. The fatality rate in the commercial fishing industry is 29 times greater than the worker death rate average across all industries in the nation. Nearly half of the deaths happen following a vessel disaster. From deckhand and processor to engineers and the captain, the Jones Act covers all workers aboard commercial fishing vessels. Second, tug and port workers. Tugboat and barge owners are often private companies that prefer to maximize profits at the expense of making reasonable investment in safety. The power of a tug combines with the weight of a barge to create a powerful force on the water, and workers risk catastrophic injury or death from slips, fall, or being knocked unconscious or overboard during line handling and parting. Workers can sue the ship's owner, captain, or the co-workers when they can prove negligence or fault of those parties in causing the accident. Railroad workers are another group of employers who are excluded from California workers' compensation. These laborers are instead covered by the Federal Employers' Liability Act or VELA. VELA operates very similarly to the Jones Act in the way claims are handled. The Morris Law Firm has extensive experience and success handling VELA or railroad claims for injured railroad workers, and we transfer that knowledge, skill, and experience to our representation of injured seamen under the Jones Act. The Jones Act is a very employee-friendly law. It places a great burden on a seaman's employer to ensure that the seaman's workplace is reasonably safe. An employer can be held liable under the Jones Act for all types of unsafe conditions on a vessel, such as grease or oil on the deck. Second, breakage of equipment. Third, improperly maintained equipment. Fourth, the employer's failure to provide crew members with the proper equipment for them to do their work. Fifth, improper training of the seamen or of the crew in general. 6. Unsafe work method. 7. Negligence of the seaman's co-workers. And 8. Assault by a co-worker. A Jones Act employer can even be liable for hiring and or failing to fire a violent crew member. Ship can be two places, but if a crew member has developed a reputation for being violent or even threatening with his co-workers, the employer has a legal duty to get the person off the vessels. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.